take
I
care
don't
of
know
the
how many
financial
women are
needs.
going to die over the holidays from somebody that's a domestic abuser either, Mr. 5000.
Notice how the court opens with a strong, dramatic statement. Already, we're seeing the stakes. This isn't just paperwork. These are lives potentially at risk. Keep your eyes on how the judge and attorneys navigate these initial tensions.
Workouts case, People versus Michael Donald.
Good afternoon, Your Honor. James Fifelsky on behalf of Michael Donner, who's to my right. State your name.
Michael Donner.
Your Honor, we're ready to proceed with exam on this case.
Your Honor, at this time, people are unable to see this in counts 1 and 2 to ask for count 3 to be remanded down to the district court.
Move for dismissal of counts 1 and 2. I would like to address bond on count
If
3.
it's going to be that same argument, we're going to have a problem.
Well, it's slightly, Your Honor, because of these
Counts
circumstances.
1 and 2 are dismissed. I'll continue with not guilty plea.
Here's a classic courtroom move. The defense is negotiating counts and bond before we even dive deep into the trial. This is where strategy matters. Dismissals now can drastically shape what happens later. Ever wonder how much leverage a skilled lawyer really has at this stage?
What is count 3? What do you have as count 3?
Domestic violence first offense.
That's what I've got too, Judge.
No,
This is wrong.
that's wrong.
This is wrong.
Those 1 and 2. And it's a DV. They never included count 2. Well, no. Yeah, they never included the real count 2. And so count 3. Count 2 was interference with electronic communication. Actually, there it is. It's right there. But I got it entered there. Can you check? Did this come directly from JS? Can you check what JS has?
This is a separate document by the clerk's
Right.
office.
Right. So check to make sure JS has 3. Because otherwise they're going to have to correct something. I'll continue to defendant's not guilty plea as to count 3.
Watch the back and forth about count 2 and 3. These clerical mix-ups might seem small, but they can delay proceedings or even change the outcome. Court clerks and document accuracy, more important than most people realize.
Set this for pretrial before Judge Fishel. January 15th, 2026. At what time? 10:30. Before Judge Fresh Hour. As to bond.
Your Honor, is that at 1484 or 3?
It's a 1484 case.
Thank you, Your Honor. Your Honor, as to bond, I would ask, given the circumstances that 2 felonies were dismissed, and this is a unique situation in terms of, I think, much more hardship to my client's family, including his wife, than to him himself. His mother-in-law has reached out to me to beg me to try to get him out of jail to take care of this family. His wife is a stay-at-home mom. He's the sole breadwinner. Even if she has to get a job for the next 3 months, she's got to pay extra daycare expenses to get these kids daycare, because otherwise she would be taking care of them while my client's out working. I just spoke to his mother, who said he could reside with her in Chelsea. I've got an address. I'd ask the court to tether him to the address, allow him to work. The court can assess his whereabouts and ensure he doesn't.
Now we're in emotional territory. Family hardship, childcare, and the pressure of being the sole breadwinner. This is the human side of legal proceedings. Courts don't just weigh guilt. They consider the broader impact on innocent parties.
Violate anything. He has never failed to appear at court. He turned himself in on this original warrant, I believe. And I understand we had a bond violation before, and I would just...
Oh, tools. It's not just one.
I
He just doesn't
understand.
think he has to abide by the court's orders. That's the problem.
Well, I don't think it's that. I think that he had poor judgment in terms of how he went about what he had to do just to get some things and see his kids. And I understand it is a violation. But he has now spent the last 12, 13 days in custody. That certainly sends a strong message. And just, again, we're talking about Christmas time. And he's got 5 young kids who rely on him to take
I
care
don't
of
know
the
how many
financial
women are
needs.
going to die over the holidays from somebody that's a domestic abuser, either, Mr. Fajowski. So I don't think we ought to be using Christmas time as some type of mitigating factor.
Well, I would just ask, given the fact that it is nobody's going to, but given the fact that, yes, young children look at this as a special time, and I get it. My client is the one who made whatever decisions he has, but he's certainly willing to do whatever the court requires of him to ensure his appearance and safety in the community.
Response from the people.
Your Honor, at this time I would object. It was 2 clear bond violations. He was given clear instructions and arraignment not to contact the victim except for third-party contact about child care. He broke that, and then he was at the residence. And I mean, it can't be any more clear. He was seen leaving the residence. He was told on. So I have concerns he can't follow court orders. He broke 2 of the conditions he was given in arraignment almost immediately after arraignment. First being calls, and then after he gets out of jail, bonds out, right to the house. So at this time, I'm going to object because I don't think he can follow court orders.
His bond at this point is sitting at revoked. I will grant.
The prosecution is pushing hard here, pointing out clear bond violations. This is a turning point. Can the defendant be trusted to follow court orders? This is where the judge must weigh past behavior against potential risk. It's tense, real, and very much a legal chess match.
Name a bond on this case. I'll grant him a $50,000 10% bond. Same conditions apply. I'll just say this: if you don't listen to him and you get before Judge Freshour, you're going to have heck of a pay. You think this was rough? I would indicate that there will be a GPS tether prior to release. That GPS tether, I am not going to give a release to work. I'm going to let Judge Freshour make that decision as to how far out he can go and what he can do, because he just can't seem to follow anybody's instructions. So I think it's probably better that it come from her.
And here comes a dramatic resolution. GPS tether, home confinement, no release. The court is sending a clear message. Follow the rules or face consequences. This is a reminder that even in complex legal negotiations, accountability is key.
So it's going to be a GPS home confinement and with no release for anything at this point until he receives permission of the court to do so.
Thank you, Your Honor.